from taking any steps to enforce the bond between the claimant and the defendant pending the determination of this suit. The application is supported by a 19 paragraphs affidavit sworn to by the claimant himself. A written address was also filed along with the motion on notice. Kirian Omang Esquire counsel for the claimant respondent in oral adumberation before the court informed the court that he is relying on the deposition contained in the affidavit in support of the motion on notice. Counsel also adopted the written address file along with the motion on notice as his argument. Counsel asked the court to grant the application as read. In the affidavit in support, it was deposed that the claimant is an employee of the defendant, sponsored to study at University of Glasgow, United Kingdom. However, the defendant refused to pay the balance of the money approved for him to pursue his PhD at the said university. And this has affected the timing for the finishing of the program with 2 years. The refusal of the defendant to pay the balance of the money for the study for the claimant has also made the claimant to resort to other means to source for money to complete his studies. In the written address, a single issue was formulated for resolution to it, whether this honorable court can grant this application. In arguing the sole issue for determination, counsel refers to the case of Alcatel Cable Metal Nigeria PLC versus Ojubide and the book on injunction and enforcement of orders by Chief Ape Babalola SAN, and submitted that the claimant applicant has satisfied all the conditions set out by law for the grant of interlocutory injunction. On this submission, reliance was also placed on the case of Mbali versus Amobi, reported in 2011 LPLR 3988 Court of Appeal. Counsel also referred to the case of Palomo versus Banigwe, reported in 1998, 7 Nigerian Ukilolo report, part 559, page 679, where it was held as follows. And as already observed, it is not necessary that for the plaintiff to succeed. The court in an application for interlocutory injunction should find a case which would entitle him to relief at all events. That is not the law. It is quite sufficient if the court find a case which shows, as in the present case, that there is a substantial question to be investigated and that the matter ought to be preserved in status quo ante bellum until that question can be finally disposed of by the court. In concluding his submission, counsel asked the court to, in consideration of the compelling depositions in the affidavit and the argument canvassed in the address, exercise her jurisdiction in favor of the claimant applicant and grant this application, as according to counsel, the success of this application would better meet the end of justice. A reaction to the application for interlocutory injunction, the defendant respondent filed a 15 paragraphs counter affidavit sworn to by one Gift Asian, principal registrar in the legal department of the defendant. A written address was also filed along with the counter affidavit. Patrick Ekuri Esquire, counsel for the defendant, respondent relied on the averments in the counter affidavit and adopted the written address as his argument. In the counter affidavit, it was deposed that the claimant was a staff of the defendant engaged as an assistant lecturer in the Department of Anatomy in 2013. The claimant applicant applied to the Tertiary Education Trust Fund, TED Fund, through the defendant for sponsorship to pursue a PhD degree at Glasgow University in the United Kingdom. The defendant respondent never sponsored, nor did it undertake to provide the claimant with a scholarship as consideration to serve the defendant for a mandatory 7-year period. The claimant applicant funding was undertaken by the TED Fund. The respondent knows as a fact that all payment due to the applicant was paid, including his salaries, which was running even though the applicant was not in the country and at work in the sum of 9,177,325 naira 11 kobo. In the written address, it was argued that the applicant has applied to TED Fund for sponsorship through the defendant to study in the University of Glasgow. The duration was 3 years from 2014 to 2017, and the total sum for the period was 20,266 naira 485 kobo. A further sum of 5,099,765 naira was further approved and paid to the claimant applicant, bringing the total sum paid to the claimant to 28,087,320 naira 19 kobo, as shown in Exhibit B2. Counsel drew the attention of the court to the defendant's continued to the fact that the defendant continued to pay the claimant's salary while he ran his studies abroad. But until the time of making this counter affidavit, the claimant had not returned to the country since 2017, when he was expected to return. The defendant even gave him a period of grace in 2020, but to no avail. Counsel submitted that for an injunction to be granted, there must be a legal right according to counsel for the claimant. According to counsel, the claimant has not placed sufficient materials before the court for the grant of the praise he is seeking in the affidavit in the motion on notice. Counsel relied on the case of Umar versus Effiong. Counsel also referring to Okomo Oil, Farm Oil, and the case of Nigeria Civil Service Commission versus ASEAN, submitted that the conduct of the claimant is not deserving for granting of interlocutory injunction. Counsel asked the court to simply use the counsel argued that the claimant is simply using the instrumentality of the law to stop the defendant from enforcing the bond freely signed by him. Counsel asked the court to refuse the application for injunction and order accelerated hearing. Court decision. I have carefully considered the claimant's applicant's motion on notice for interlocutory injunction, the affidavit in support with the exhibit attached therein, the defendant respondent counter affidavit and the exhibit attached therein. I have as well considered the written addresses of counsel for both parties. Having attentively listened to the oral submissions of counsel for both parties in their respective case, it is clear to me that this court is to determine what this court is to determine is whether, in view of the facts so far disclosed in this suit, the claimant applicant has made out a case for grant of an order of interlocutory injunction. An order of interlocutory injunction is an equitable remedy issued or granted by a court at the suit of a party complainant directed at a party that is a defendant in the action, or to a party made defendant for that purposes, forbidding the latter to do some act, or to permit his servant, an agent, to do some act which he is threatening or attempting to commit, or restraining him in the continuance thereof. Such act being unjust and unequitable, injurious to the claimant, and not such as adequately redressed by an action in law. It is a judicial process operating in personam and requiring the person to whom it is directed to do or refrain from doing a particular thing. See the case of Nigerian Telecommunication Limited versus ICIC Directorate of Publishers Limited. Interlocutory injunction is an injunction which a court of law grant on notice in the course of pendency of litigation, and which lasts until the determination of the conclusion of it. It is granted to protect the rest in dispute at a time when the true owner is yet to be ascertained, pending the determination of dispute between the parties. See the case of Salami Basiaya, reported in 2009, 17 Nigerian Criminal Report, Part 1171, page 581. It is granted to prevent continuation of an alleged wrong act. See the case of Inandi versus Amadi, 2011, 4 Nigerian Criminal Report, Part 1238, page 582. 53. By an interlocutory injunction, the rest is preserved from being dissipated or printed away until the substantive suit is decided. This means an order of interlocutory injunction guard and protect the rest during the pendency of the action. See the case of Akibu versus Odutan and others, reported in 1991, 2 Nigerian Law Report, Part 171, page 1. The Supreme Court held that interlocutory injunction is usually granted with the object of keeping matters in status quo until the question at issue between the parties is resolved. The reason behind an interlocutory injunction to maintain status quo is to preserve the rest of the litigation from being wasted, damaged, or printed away, with the result that if the action succeeds, the successful party will have nothing or will reap an empty judgment. See the case of Oyeyemi and others versus Erewole local government, Ikile and others. See also the case of Alon versus Dandun Nigeria Limited. See also the case of Maliko versus Awache. See also Idezwe versus Ochoma, and also Nwanewe versus Nwanewe. See also the case of Stallion versus Economic and Financial Crime Commission, reported in 2008, 7 Nigerian Law Report, part 1087, page 461. The object of interlocutory injunction is to protect the claimant against injury or by violation of his right, for which he could not be adequately compensated in damages recoverable in the action. If the uncertainty were resolved in favor of the trial, in favor of the claimant at the trial, see the case Ekwenmachi versus Uku. See also the case of Ogunshola versus Usman, and the case of Adamu versus Attorney General of Nasarawa State. See also Christialis versus Maje Kodumbi, Yusuf versus International Institute of Tropical Agriculture. In an application for injunction in aid of a claimant's alleged right, the court will usually wish to consider whether the case is so clear and free from objection on equitable grounds that it ought to be interfered to preserve the property without waiting for the right to be established. This depends on a variety of circumstances, and the Supreme Court has held that it is impossible to lay down any general rule on the subject by which the court ought in all cases be regulated. But in no case will the court grant an interlocutory injunction as a matter of course. See the case of Dye Trade Limited versus Omnia Nigeria Limited. The tendency is to avoid trying same question twice and to grant injunction only in clear cases. See Down Pharmaceutical and Chemical Company Limited versus Benin Pharmaceutical and Cosmetic Limited. Generally, the most important factors the court take into consideration in the grant of interlocutory injunction have been stated and restated in several decisions, decided cases, and need no repetitions here. See, for example, the case of Obeya Memorial Hospital versus Attorney General of the Federation. See the case of Omeso versus Inebedom. See also the case of Zibolo versus Chimuba. See also the case of Palomo versus Banibe. See also Enunwa versus Obeanuko. See also the case of Leasing Company of Nigeria Limited versus Tiger Industries Limited. The one thing that is well settled in law, however, is that the grant or refusal of an order of interlocutory injunction is in absolute discretion of the court, which discretion, however, like all other judicial discretion, must be exercised judicially and judiciously, having regard to all the facts and circumstances of each case and to cases of each and every case. It is always essential to remember that in an application for interlocutory injunction, a trial judge invoke his equitable jurisdiction, which requires him to exercise his discretionary power judicially and judiciously based on the facts presented by the parties before him and on no extraneous matter. See the case of Amakre versus ICIC, and also Down versus Pharmaceutical and Chemical Company, Supra. The burden of proof on application for interlocutory injunction is entirely on the applicant, and he must discharge the burden in his affidavit. See the case of Morofula versus Kwara State College of Technology. This does not, however, mean that the applicant has a legal duty to prove the merit of the case at an interlocutory injunction. The Supreme Court in Palomo versus Banibe Sufra quoted with the approval the dictum of Lord Denny in the case of Hubbard versus Bospa, reported in 1972, 2KB 84 at 96, where he stated that the remedy of interlocutory injunction is so useful that it should be kept flexible and discretionary and must not be made subject of strict rules, said the learned law lord. It is in the light of the foregoing general principle of law on interlocutory injunction, which governs the grant or refusal of an order of interlocutory injunction, that I shall consider and determine the application at hand against the background of the said general principle of law and the facts of this case. From the affidavit evidence, from the affidavit in support of the motion on notice for interlocutory injunction and the response filed in respect thereof by the defendant, it is apparent that the main contest by the parties centers on the issue of legal right, balance of convenience, and damages. Taking into consideration the claim of the claimant, his pleading, and the disposition in the affidavit in support of the motion on notice for interlocutory injunction, the main concern of the claimant is the refusal of the defendant to pay balance of the money approved for the claimant in his case to acquire a PhD degree, while the defendant respondent by its deposition in the counter affidavit filed in opposition to the application of the claimant is to the effect that the claimant has received all the sums he is supposed to receive to complete his studies and return to the country to fulfill the terms of the bond which he resigned for sponsorship of his studies. Let me say here that the law is humble, that courts are enjoined not to delve into deciding the substantive suit or issues in a suit at interlocutory stage of the case, as doing so may prejudice the outcome of the suit at the end or conclusion of the case. In deciding application of this nature, the court should, as much as possible, try not to delve into or predetermine issues to be tried in the substantive suit, the case of Oji versus Zaria Industries Limited. See also Obeya Memorial Hospital and others versus Attorney General of the Federation and others. The court in this case, in this type of situation, do and must only confine itself to those issues necessary for the disposal of the application without more. It is for this reason that I am conscious to make any pronouncement on any issue that would be prejudicial to the main question for determination at the trial of the substantive suit. See the case of Gonaya and others versus other firm. It is in view of this cherished principle of law that I refrain from deciding the crucial questions that are to be resolved at the conclusion of the case. As pointed out earlier, the law has been well grounded by a long line of decided cases that an applicant seeking for an interlocutory injunction is calling for exercise of discretionary power of the court, which has to be exercised judicially and judiciously in line with the well-set established principles governing such exercise. The court, in deciding whether or not to grant an order of interlocutory injunction, shall be guided by the nature of the of the serious issues to be determined, balance of convenience and status quo as proper issues to be determined, balance of convenience and status quo. It is right that in an application for interlocutory injunction, the applicant must establish inter alia his legal right to bring the application. See additional Arowolo. The claimant in this case is seeking to determine the determination of his entitlement in view of the provisions of Section 71 of the National Industrial Code Act 2006 and Section 254C1 of the Constitution of the Federal Republic of Nigeria. The claimant has the right to approach the court to seek remedy as he is currently doing. The remedy of injunction, as the name implies, is a temporary remedy that lasts till final determination of the suit. Being an equitable remedy, it is also discretionary. Hence, the central objective of the court is to protect the property, is to protect the party applying for injunction against injury or violation of his right for which he could not be adequately compensated in damages recoverable in the action. If the uncertainty were resolved in his favor at the trial, see the case of Obeya Memorial Hospital versus Attorney General of the Federation. In the case at hand, the main grounds of the claimant borders on balance of money for his studies. If at the end of the trial, this court found the claimant is entitled to the various sums of money claimed to be entitled to, on one other pivotal point of law governing the grant or refusal of an order of interlocutory injunction is that the claimant need for protection by way of interlocutory injunction must be weighed against the corresponding need if the defendant to be granted against injury that he may suffer should the application for injunction be granted. The principle should be applied to the facts of each case. Obviously, from the fact of the case at hand, the defendant respondent is a creation obviously from the facts of the case at hand, the defendant respondent is a creation of the law with mandate to appoint, promote, and discipline employees, as well as training of the employee. This means that an order of interlocutory injunction is issued to grant against the defendant. The injunction will, if it is granted, the injunction will impede on the exercise of the statutory mandate of the defendant respondent. It is my view that any injunction at this stage will work more injustice to the defendant than to the defendant, considering the mandate given to it by the law. To my mind, the injury the defendant respondent would suffer would far outweigh the injury, if any, the applicant would suffer by the refusal of the application. It must be remembered that the defendant is performing statutory duty imposed on it by law. The court does not have the power without special circumstance being shown to stop the exercise of statutory power. This is the case of Akibu versus Oduta and Supra, where the apex court ruled that an injunction cannot be issued or granted in this case as as it has the effect of depleting the workforce of the defendant respondent, which in turn will affect the student of the institution. The law requires that there should be enough evidence that the applicant will suffer more inconvenience if the application is refused. These facts must be clearly set out in the affidavit. See the case of Africa Continental Bank versus Awogboro. See also the case of Sulu Gambari versus Bukola. See also Modile versus Governor of Lagos State. Adewale versus Governing Council of Ekiti State, Governor of Ekiti State Supra. Shaibu versus Muazu. However, in the case at hand, the claimant has not supplied enough materials to show that his balance of convenience is in his favor, more particularly one from the disposition the claimant However, in the case at hand, the claimant applicant has not supplied enough materials to show that the balance of convenience in his favor, more particularly when from his deposition, he claimed has not supplied enough materials to show that the balance of convenience is in favor of the claimant. More particularly when from the deposition of the claimant, it is now clear that the defendant is currently working. From all I have been saying above, the claimant applicant has woefully failed to convince the court as to his entitlement to the grant of an order of interlocutory injunction due to lack of credible evidence From all I have been saying above, the claimant applicant has hopefully failed to convince the court as his entitlement to the grant of an order of interlocutory injunction due to lack of credible evidence to show the damages cannot adequately compensate him for injuries he may suffer at the end of the trial if the case goes his way. It is clear from the substantive suit that the claimant is claiming payment of various sums of money. In the circumstances, it cannot be said that damages cannot compensate for loss in respect of the praise of the claimant. The claimant has also not shown that the balance of convenience is on his side, as it is clear from the evidence before the court, the balance of convenience is on the side of the defendant, who has student in the institution that are studying, and the grant of this injunction may have a far-reaching effect to the manpower of the university. The claimant applicant's application for interlocutory injunction therefore fails, and same is hereby refused. In the circumstance of this case, I order accelerated hearing of the substantive suit. It is hereby ordered accordingly. Ruling entered accordingly. I made no order as to cost. Immediate.
My Lord, we respectfully thank you for the well-considered and lengthy ruling. We are most grateful, sir.
Yes, I have granted accelerated hearing. Therefore, I'm going to give you 2 days for the matter.
My lord, before the 2 days for the hearing, we actually have
Yes.
a motion for amendment. We intend to amend our process before the court.
When was it filed?
It was filed on the 9th of November, 2021. And same has been served on the defendant respondent.
But you know the matter was slated today for
ruling.
what do you call it, for ruling only.
Yes.
So
Yes,
in view of the absence of the other counsel, so it would be appropriate to consider this application,
as the court
since the purpose of today's sitting is just to deliver ruling. Let me find a date for you that you come and move that motion. Then on that day, we take the 2 days for the hearing.
As the court pleases. We are grateful, sir.
Registrar, quick. Find a date. Can we get a date in the March?
Nongo. Who will sing it? You put it over. You put it in.
How now?
Inongo.
It be like Inongo now.
So the registrar will just give us date for March.
Mhm.
Why the registrar delay? The man just going to even tell me since they go. He just say the registrar find date for March.
Yes, I was there now.
Yeah?
I said yes, I was listening now.
Now him wear that nose mask.
Yes, yes.
Okay, I think say na my guy for Abuja.
Those guys are. Yes.
You come back on 5th April for the motion. Then on that day, we take 2 clear days for the hearing of the matter.
As the court places, 5th of April.
Yes.
We are grateful, sir.
This case is adjourned to 5th of April 2022 for hearing of motion on notice. Hearing notice to be issued and served on the defendant.
As the court pleases.
Proof of service to be kept in the case file. So case stand adjourned to 5th of April. Thank you very much, Council, for your cooperation. Yes, we have come to the end of the virtual sitting. The administrator, you can end the sitting. Thank you.
All right, thank you.
No, so we're not going to talk again. Me and we're not going to talk again. It can't be used now.
Okay, BSA was also listening.
Yes, it was. Leave me. Say that. Leave me.